hopefully you guys have enjoyed things. I'll find out about that next time. But we're just setting up here. Are we all ready to go? Okay.
Yeah.
All right, good. So let's start with Gillian telling us about the prize today.
I'm Gillian Parker. I'm in the philosophy department with John, and I happen to be the new director for CELS, the Center for Ethics, Law and Society. And I just wanted to tell you briefly about what's happening today. We're hearing from two prize winners for the Warren Court essay competition that every year CELS runs. And I'm just really here, John's going to introduce our two winners. I'm just here to encourage you to submit your essays to CELS, to the Warren Court essay competition next year. You can go online to the philosophy department. To the left, you'll see a link to CELS, and then when you click on the link, you'll see a further link to the Warren Court essay competition. It's a competition for any student at Sonoma State, undergraduate students, in any department. You don't have to be in the philosophy department. And the essay would be an essay in something philosophical but political, ethical, something if you're into criminal justice and into issues of justice, global justice, social justice, justice here in our streets, any essay that you might have written along those lines. And if you're unsure if your essay is on topic, you can always consult with someone in the philosophy department. Shoot me an email, say, would this be a good entry for the competition or not? So we run this competition every year, and what we're looking for is more people to submit their essays. The more the better a competition we can run. It's great to have a prize in an essay competition as you graduate here from Sonoma State. To have that on your resume is a wonderful boon, right, to have. So think of it in those terms. But there are also monetary rewards as well. So the first prize winner gets $500, second prize winner $250, and anyone who gets an honorable mention will get $100. And I encourage you to submit essays year after year, because what I have noticed is some people start out in their sophomore year, perhaps submit an essay, they get an honorable mention, and by their third time around, when they're seniors, they win first prize, right? Because they get to know what it takes. So don't feel despondent or disillusioned if you submit next year and don't get anywhere. Keep submitting, right? Because your time will come, and it's a fun competition. It's not highly competitive in the sense that we don't get 100 essays, right? We're looking for something maybe between 10 to 15 essays max, I think. So, you know, you've got a good chance if you submit an essay to actually come somewhere in the winning rank. So next year, do it. I encourage all of you to do it. So anyway, John will take over from there.
Okay, so we have two speakers today, and the award committee didn't really rank these two papers. They were very, very, both good papers and both around the same quality. So I'm just picking speakers in random order, just doing it by alphabetical. So our first speaker today is going to be Brandon Miller, and you'll have about 25 minutes, and then Emily Henry will come next. Okay.
25 minutes, holy cow, okay.
It's not a lot.
Oh, it's more than I thought I was going to.
Oh, it's more? Oh, okay. Yeah, I can't talk in less than an hour, so.
Okay, can everyone hear me okay? I have a kind of a quiet place. My name's Brandon Beller. I wrote an essay. This submission was an assignment for my Philosophy 303 class. I wanted to thank, before I started, my professor Megan Burke. Without their constant revisions and support and encouragement, I wouldn't be here right now. So I wanted to, I'm just going to start with, if it's okay, I wanted to read this paragraph from my introduction because I feel like it encapsulates the essay, or the essence of the essay. As Carol Pateman indicates at the beginning of The Sexual Contract, much can be gleaned from how human beings order themselves in the social world by examining the kinds of stories we tell. Since the 17th and 18th centuries, the social contract has been the myth from which the ruling elite in the United States and other Western countries have legitimized state power and our organization in the civil sphere. However, critics of the classical social contract, like Pateman and Charles Mills, have revealed its insidious nature as a justification for the subjugation and exploitation of one class of humans, namely non-white and non-male, by another class of humans, white males. Modern contractarian philosophers like John Rawls have attempted to save social contract theory by developing a truly beneficent moral contract. However, even his optimistic account of moral equality is hindered by social realities that escaped his episteme. Indeed, Mills describes in his racial contract an epistemology of ignorance, which prevents its signatories, hegemonic whites, from being able to understand the social injustices they perpetuate as necessary conditions of maintaining their privileged being. If the beneficiaries of this racist patriarchal contract are epistemically compromised, insofar as they cannot perceive the injustice of their design, then they could never conceive of a morally just social contract. I argue, not only do we need a new myth to legitimize a morally just organization of social power, but also that only those who are not epistemically compromised should be the architects of such a myth. Now, to make this clear, I use the Tucson, Arizona Ethnic Studies Wars as a case study. For those of you who don't know, between the years of 2006 and 2012, the Tucson Unified School District was in a very heated legal battle to determine the fate of their Mexican American Studies program. The program was criticized by the state superintendent of schools, Tom Horn, for being segregating students based on race, for implanting within the students seditionist or revolutionary left-wing radical ideals, and sowing resentment of mainstream white culture. Of course, the program did none of these things. What it did do was it gave the Tucson's predominantly Latino population, about 63% as of 2010, it gave them better standardized test scores. They were graduating at higher rates than students who weren't taking the program. It gave them, on a more personal level, the ability to connect with their culture, with their history, and not, say, the histories of their oppressors. And so I argue that this Tucson case demonstrates the urgency of my position. We see a real example of epistemic injustice. Certain knowledges are being suppressed to maintain and reproduce the dominant episteme. And so I bring in a lot of Charles Mills, I bring in a lot of Carol Pateman, because I believe that their critiques, the sexual and racial contracts, are what we see today. It's not what you usually think of the classical liberal philosophers, all men are created equal. We know very well who they were talking about. We know they were talking about predominantly white men. And that specifically, as Mills explains, non-whites were excluded from this consideration as full citizens. And there's another, as I alluded to earlier, disturbing quality of this racial contract, insofar as, and I'll quote Mills, because he says it best. If I can find it. Thus, in effect, on matters related to race, the racial contract prescribes for its signatories an inverted epistemology, an epistemology of ignorance, a particular pattern of localized and global cognitive dysfunctions, which are psychologically and socially functional, producing the ironic outcome that whites will in general be unable to understand the world they themselves have made. So, if you have a government like ours that's populated primarily by white men, and if these people are incapable of understanding the social realities of marginalized groups, then how is it that they can make social policy decisions that affect these people's lives? That's the general conceit of my argument. And I argue, furthermore, that we need these marginalized voices within positions of government in order to create a sort of new social contract, a more just social contract. I bring up Rawls really because his methodology is really attractive. He starts from the original position. He doesn't say, like, humans by nature came, we assembled together and we had a certain purpose to civilize ourselves. He says, you take a hypothetical situation and you start at what he calls the veil of ignorance. So we don't presume to know where we're going to end up socially in a class system. We don't know whether we're going to be rich or poor, or black or white, or young or old, or abled or disabled. He just says, start from here, and then figure out what it takes so that everyone can have the most just opportunity. I don't necessarily agree with starting at the veil of ignorance. I think that it runs the risk of you lose those marginalized voices, you lose those people who have a very specific outlook on the world and a specific perception of justice. But I do like that he starts at a hypothetical, that we don't need bogus human nature claims to figure out what we want to do to be a just people. We can just think about what justice is, figure out what it would take to do that, and then do that. So I really like that methodology, and I think that within systems of government, you have people who are in a position of power to make influential policy decisions. These positions should be filled primarily with marginalized representative voices. And there shouldn't be as many white folks in government. So that's the general idea, I guess. I didn't know I'd be speaking for probably 20 more minutes, but yeah.
That's fine. We will have, if you want to stop now, we will have some time for questions at the end, so
Okay.
people can mull it over and then ask you some questions when we get to that point.
Okay.
So thank you very much. Okay, so our next speaker is Emily Hinton. You'll have recognized her from student government. She's played many different roles in student government here on campus. And let's give her the floor.
Great. Thank you. I also didn't prepare any sort of lecture or anything for 25 minutes, so I'm just going to kind of touch on my paper. Again, my name's Emily Hinton. I'm a fifth-year student here. I finished studying philosophy last year, and this paper was for one of my classes. It's more of a relaxed or loose philosophy paper, different from more structured philosophy papers as the one that was just presented to you. It was inspired by our political climate right now. So my paper is titled "Back in My Day, We Could Say Whatever We Wanted," and it's around the idea of language and kind of addressing the idea between free speech and hate speech, and which one is appropriate, what direction we should move in potentially censoring speech or not. And I plan on reading a portion of the paper that will hopefully capture the main argument of the paper, but I think a lot of movements right now that are kind of addressing this idea are trying to figure out whether this is a culture change that our nation needs, or whether you can change culture through policy, or whether we need to change culture with culture, and the best way to do that. And so this touches specifically on offensive language. I think that is, I'm not sure the right word to use, but just a trending term right now, that people are easily offended or too easily offended, or whether there's actual merit in offensive language. So I'm going to read just a portion of this, and hopefully you'll understand better. So often people will mislabel situations in which a person's behavior leads an individual to a state of discomfort as an act of offense. However, I argue that something is only offensive if and only when it leads a person to a state of resentful displeasure due to the wrongful conduct of another individual, and that conduct is supported by a system of oppression that the targeted individual suffers from, or a group of people have once suffered from, in which the repercussions are still in effect today. So more focused on language that might hit on systems of oppression, institutional systems of oppression that are in effect today, if that makes sense. So therefore, this form of offense is no longer only causing a person some discomfort, but it is promoting or reinforcing harm. So harm then is the key component that determines whether a wrongful act is to be considered offensive as opposed to just distasteful. In that case, it is important to clarify that I am only arguing for offenses as I have defined to be subject to legal regulation. So later I argue whether that specific language should either be censored, that there should be some form of censorship of hateful speech rather than freedom of speech. And later I go into the distinction between that. But I think oftentimes now, specifically in our political climate, some of our discussions tend to fail because there's a misunderstanding of semantics, that we're not necessarily talking about the same thing when we're using these terms. And so I think it's really important to define offensive, and so that is what I do in this paper. So then situations that pass annoyance, disappointment, disgust, embarrassment, and other various disliked conditions without the aspect of resentment or harmful nature are not offenses, but instead nuances and are not worth regulating. To further distinguish a true offense, consider this example. If an individual spends her life targeting tall people, claiming that all tall people are the least intelligent, most unattractive, horrible human beings on earth, a tall person is most likely going to feel hurt by this claim and may consider that statement to be offensive. The language itself, though, and the impact it has on tall people is not enough reason to infringe upon a person's freedom of speech. Yet, if an individual labels and targets black people by spreading the claim that all black people are lazy, dangerous, and unintelligent, or including some form of a racial slur, not only will this language lead black people to a mental state of discomfort, but in addition, it causes this group of people harm by promoting a negative stereotype that's been previously established, existed for centuries, and affects a black person's existence in a society. Since racism as an institution exists and carries the weight of social and political inequalities for groups of people, the effects of racism are unavoidable and have been in existence for a long duration of time, and therefore racism is harmful and the use of racist language can be considered offensive. Even if the language being used is not directly intended to be racist or cause direct harm, keeping racist terms around prolongs an era of oppression that carries historical harm. The difference is that people who are tall or groups of individuals with the identity of tallness don't face systems of oppression within a society based solely on the characteristic of being tall, and they have the ability to walk away from the situation facing no ramifications to follow that experience. Tall people don't have to worry about losing job or housing opportunities or receiving a lower quality of education due to their height alone. Although unkind, mocking tall people is, in this sense, is not to be considered offensive. So I think that essentially captures the main argument, and then I go into using Mill and John Locke and kind of looking at the foundations of government, the expectations of government, and a society that we live in. I think sometimes when we have these discussions as well, a group of people might think that it is the government's role to protect this group of people and censor that language, and another group might think that that's not the government's role. And so I think it's really important for us now, I think that our political climate right now is really divisive, and I think sometimes it's just a matter of semantics or expectations of a government that differ, that we haven't defined or that we need to get back to defining, which our classical political philosophers do, and I think it's important to revisit that notion. I also examined an article called "I Don't Know How to Explain to You That You Should Care About Other People." I'm not sure if any of you have read that, but it also just really touches on the point of empathy and expectations in interacting with people in a society, and expectations of government in that role as well. So essentially, I came to the conclusion that that only offensive language might have merit to be censored. I'm still been having recent conversations with other students in the political science department and the philosophy department about the best way to address racism or systems of oppression in our nation, and whether that should be done through policy or culture, and the best way to address that. In the paper, for the purpose of the paper, I came to the conclusion that what I define as offensive language has merit to be censored or regulated. I'm not sure if anyone has heard, recently in Canada, I think a bill passed to require the use of pronouns, and there's a form of consequence if that isn't respected. And so that is a way of addressing culture through policy, and it's still a recent bill, so I think it's worth value to see how that plays out in Canada, but that's just an example of how I was arguing last night actually with someone, and they felt that that was an infringement upon freedom of speech, but I think that the violence or harm that people face, specifically in this case, transgender lives face from the use of not using pronouns, or that there are harmful and actual, there's a reality to using that language, which would be the case in my paper as well. So that might have value in regulating, but I think it's still a recent movement of how to address this culture, and whether we have a responsibility to do so, a civic or moral responsibility, or whether just as people in a culture, whether we should be approaching it that way. So yeah, I appreciate the opportunity to have submitted my paper. This is my second time submitting a paper, and I think it's a really great opportunity that the CELS department provides for students to engage in competitive academia. So I encourage you all to submit papers you've written, or write a paper for this purpose. I mean, if anything, it's great just to be able to engage in these conversations with students, your fellow students. So thank you.
Okay, excuse me, I've got a nasty cold I picked up over the holiday. So we have a little bit of time for questions. Hard to believe that you could listen to these very provocative speeches without having some opinion. These are really important, both papers address really important issues about social justice. So, any questions, comments? Yeah. And then address it to who you would like to answer.
Yeah, so that's Emily, right?
Yes.
Yeah. I was wondering, there'd probably more work to continue what you started here, was to look at what we might call, with a sort of philosophical ugliness, a hierarchy of culpability. I mean, once we do recognize that there are certain things that shouldn't be punished legally, we still have questions of, what's moral, questions of what's illegal, what's immoral, and what is simply discourteous. And just because we say something isn't illegal doesn't mean we shouldn't condemn it or so I was wondering whether you had any ideas about how we would rank these kind of things. And, I mean, it's still, just cruel to mock tall people, or anybody else, really, you know. So I was wondering if you had any ideas about how you would rank these, particularly the issues of, you know, there are things that are actually immoral, and there are other things that are just sort of rude, you know. Do you have any ideas about how you might want to draw the lines between those categories?
At the time of writing the paper, I thought that, like that hierarchy, so there are things that are rude, but then there are things that are immoral, specifically things that have historically created oppression for groups of people, and those things should then be considered illegal. So then you'd have this group of illegal or just rude, and no sort of in between. But now I think, I'm not sure that's the best way to address it in discussions that I've engaged in further recently. I think it's difficult to...
Because we have a lot of things that, I mean, part of what it means to have a separation between church and state is to say that there are a lot of things that you may say are immoral, but that we don't let them be illegal. I know a lot of people make those claims about abortion, for example, that there are some women who feel that abortion was, you know, she said, I can imagine we'd have laws that would say there would be abortions which I personally would feel immoral, but I don't have the right to make the judgment for those women, and so therefore those immoral abortions should be legal. You know, so you could draw the line, and there are a lot of things along those lines, as long as we accept the idea that part of what it means to have separation of church and state is that our values don't have to be legislated. You know, there are legislations that say, you know, my right to swing your fist ends where your nose begins and so forth. But that doesn't mean that you can't say that there are other things. I personally think what you're doing is scummy, but that doesn't mean I think you ought to be illegal. I mean, one of the examples, I think there's something really sick about the fact that Mitt Romney owns 15 houses. You know, I mean, if you own 2 or 3, I'd understand it, but how in the world are you ever going to find time to own 15 houses? You know, to go to all of them, you know? What's the point of owning 15 houses? But I don't think it should be illegal for him to own 15 houses.
Yeah, I think in that case, it should only be illegal for him to own 15 houses if him owning 15 houses is hurting a specific group of people, specifically minority groups of people. So that, yes, there's immoral language or rude language, and then there's what's illegal, and how do we determine those? I think the question even of how do we determine those categories is really important to have. I think the question is, like, does the government decide that? Do the people decide that? Which people gets to decide that? I think it's really important, at least in the example I used, that these minority groups are involved in those discussions, and as we heard from our first speaker, we don't have people of color in representation in government right now. So,
not proportionally.
yeah. So I think it's really important for the affected groups to be involved in those conversations. I don't think it's even for me to decide what is offensive language. It was great to explore the topic for my paper, but I wouldn't say that I'm the one who determines what is offensive language, or what is immoral and what is just rude and what is illegal. But I think, especially now, it's important for us to move in that direction of determining those, because I think a lot of the failures in our discussions happen around semantics, that someone might be saying that something's offensive and they consider it illegal, or they consider it immoral, and the other person they're talking to just sees it as rude. And so then you're not having the same conversation. So I think it's really important to lay the foundation of the conversation first, in the terms that you're using, or else you're not having a coherent discussion. I don't know if I really answered your question.
No, that helps a lot, yeah. I think a lot of it is just, you have to recognize that there's a certain irreducibility to experience, that if you do the game of the veil of ignorance that Rawls says, and you roll your eyes back and you imagine what it's like to not have something, or not have somebody insult you, if you haven't had the experience, you can't make that judgment. You can't just put yourself, in other words, you can't really put the veil of ignorance on yourself.
Definitely. I think just
I
one
have a
last
question
point
over
to
here,
respond
real
to.
quick. Do you want to?
Pass on.
You're going to pass? Okay, go ahead.
Okay, just one last thing. I think specifically, like with the owning 15 houses example, that I think we have, the government at least has an obligation to create equal opportunity for people in a society. So that's kind of what I was trying to touch on in my paper. Like, language should only be considered maybe illegal if it's like reinforcing these institutions that create unequal opportunity for people in a society. So just saying that like you don't like the fact that someone owns 15 houses, but then like attacking a group of people that doesn't have the same opportunities as you in a society, I think is where I would say the government has a responsibility to address that.
Yeah, because there'd be real concrete evidence that it was hurting somebody else rather than just making them feel bad. You know, I get annoyed thinking about those 15 houses, but not really being hurt, not just annoyed by it.
Okay, next question.
Yeah, I have a question for both of you, but I'll start with Emily since we're already there. So I'm sympathetic to needing to create and wanting to create a social world where marginalized people feel comfortable, supported, and where they have the same life chances as kind of privileged groups. But I guess I'm hesitant about doing that through the law. And so here's why, and I just wonder, and it seems as if you're slightly hesitant too, so I guess I'd like to hear more about it, but here's my hesitancy. So historically, the law does not work to benefit marginalized people, and so the question then would be, what's the guarantee that it will? So here's a specific example I have in mind. So let's say we regulate the use of the word faggot, right? Which in queer communities, which are my communities, that's not always an offensive word. But if we make that an offensive word, then for those of us who it's actually an emancipatory speech act, it becomes a possibility to incarcerate us. And that can actually backfire in really significant ways. And historically, the use of the law precisely does that to marginalized groups. So there's a risk, there's a huge risk. So on the one hand, there's a debate from those of us who want to make an inclusive social world and suggest the law is the right way to go. And then there's also another angle to come at and suggest that the law is not at all the way to go. And that actually there's a different way to go, and that's a kind of a cultural shift, right? That changes the way in which people kind of engage with one another. So there might be still a role of the government to play in that cultural shift, and I think one different way to understand the tension we see today, because like regulation over offensive speech is an age-old question. It's not new. But what we're seeing today is a debate over, well, it's my right to express myself in society in this way. And so I guess I just wonder, why do it through law? Like why is the role of the government, why turn to the law there rather than something else? So I guess I just wonder if you have anything to say to that.
I think I definitely agree with you. I think I really just went in that direction for the purpose of the assignment. The paper and the topic itself is really interesting to me, and I'm passionate about it. And I definitely would like to explore and develop the argument further, and that might take it in a completely different direction. There are aspects like that that I didn't even consider when writing the paper, but it's definitely important that the government doesn't always serve especially marginalized communities in the best way. It can even end up being harmful. I think I tend to approach these things from an idealistic mindset or approach, that ideally I would like the government to serve this purpose and it would serve the people in the best fashion. And so ideally I would like if the government, if it were to censor this language, it wouldn't have negative ramifications to the groups that it was intended to protect, but that's not the reality. And so I think that is often where some of my arguments fail, is that I need to look more at the reality of the nation we live in, where government pans out. And so it definitely is really valuable to the argument. So thank you for the feedback.
Okay.
Yeah, and I have to admit, I kind of tend to agree with it. I think there's a pull to the legal side because it can be seen as like a quick fix, even though it sounds weird to say law is a quick fix versus like changing culture longer. But I think that's like working with live ammo. It's very hard to craft a policy that benefits everyone versus just changing a culture just to be more open.
Mm-hmm.
So it can be hard to kind of get that pull to law, but I don't know if it will necessarily work.
Right. Yeah, I think that's a really great point. Did you have a?
Well, I was wondering how you might feel about other sort of non-legal but retaliatory measures such as firings and boycotts. Do you think those kind of strategies? How do you feel about those kind of strategies?
I think there's various kinds of strategies, but I don't want to take up this space. So to say that this is not my space to take up.
Mm-hmm.
There are various kinds of strategies.
Mm-hmm. Yeah, and we're really going through an interesting time, especially in the academy, because a lot of this happens right here, right? How much speech do we tolerate? Do we tolerate rude speech? Do we let professors be insulting just because they have the lectern, or do they suffer some kind of consequence? And firings and demotions and things like that can happen, especially like on Twitter when somebody off duty as a professor says something insensitive online on Twitter. What kind of ramifications should happen there? So it's definitely a time where things are changing. We also have politicians who tactfully avoid trigger words, right? But will then be super rude, right? So instead of calling out the race of my opponent, I might just say, call him Little Marco instead, right? And it does the same job, right? So it allows me to be racist without being racist, right? Is that protected speech? So I really enjoyed this paper because it really made me think about all these levels of where harm. So it seems like it's really important to make the legal distinction. Like there's a certain level of harm. When you reach that, you're now in legal consequences. But there's this whole gray area of before we get into really intense harm, where we're just being completely insulting, right? And that can have an effect of shutting down a conversation as well. So I can be really insulting and to the point where my opponents just don't want to be in the conversation anymore, and then that allows me to dominate the conversation, right? So it allows me to do a form of hegemonic strategy, right? That is not racist per se, but still comes out with the same effect, right? So I think that was really important. So maybe I'll ask a question. Do we have another question? Oh, good.
I have one question for
Okay,
you.
excellent. Take it away.
I'm interested if you could talk more about this idea of being epistemically compromised because of your own social positioning, writing this paper, and to think about if it's possible for members of multiple privilege groups, for instance, to undo this undo being epistemically compromised, and if you've thought about that and what that looks like for those of us who are, say, signatories to the racial contract, what it looks like to then kind of inhabit the world in a different epistemic way.
Should I stand up here? I don't want.
Yeah, so that way the camera can see you, and it's not just a talking voice.
Yeah. This is a consequence of me being woefully underprepared and also bad at public speaking, but
And you're so tall.
But to your question, yeah, like obviously in writing this, there seems to be an automatically undermining quality for me to speak on, like, that I shouldn't use my whiteness as a privilege. I'm like in the culture. I'm in I'm a signatory whether I like it or not. But I really hold fast to not only that it's potentially through an act of conscious resistance and conscious learning and listening and paying attention to voices and perspectives that are not your own, that you can start to break away or potentially be able to recognize the catchphrases, the usual symptoms of this racial polity. And I really, something else I wrote near the conclusion is that I really am taken with Judith Butler's Epistemic Humility. That was really the goal with this paper, was to try and, like, in conceiving of myself, conceiving of myself as a racialized being, a racialized, genderized being who has grown up in a society that has a history that I was not privy to until very recently. That I have a responsibility to take a step back, not interject, even though I'm standing up here talking to everyone, to take a step back and, say I'm not the person to be making decisions that'll affect the lives of people who I can't possibly understand unless I've been there. And so I think that if we take Butler's epistemic humility, if we the signatories to this contract sort of take that to heart and allow for the space for other voices to come in and say, like, for the offensive language, like that to your point about law, like I wouldn't be the person who would want to make a policy decision to criminalize the use of a word, because from what you said, like, I had no idea that that word could be an emancipatory term, and so like my well-intentioned decision could end up having disastrous consequences. That's why I shouldn't be making that decision. And if somebody, let's say a queer person, were in a position of government, then they might make an effort to not, because they understand the social reality. I am wary of the law's effect, like especially after reading Spade. So yeah, like I totally am sympathetic to that. But I do think that, again, with that shift to have more voices in the discussion, to have more spaces at the table, as it were, for these non-signatories to the racial to the racial contract and the sexual contract, you have more opportunities to understand, like, oh, this would be an adverse policy decision, we should try something else, maybe something that's non-law related. So that's what I say for that.
Excellent. Okay, I think we have time for one more question, if there is one. No? Okay, so we will call it quits for today, and we have a lunch if you want to participate in that, and otherwise we'll see you guys next